What happens when a founder returns to disrupt the company he built, and that company sues him for stealing its secrets? That's the collision at the center of Datto v. Slide, a Delaware trade secret case that forces MSPs to pick sides in a fight between two BCDR vendors, one backed by billions in private equity, the other led by the engineer who started it all. Kaseya, which now owns Datto, claims Slide misappropriated the proprietary technology behind hardware-independent restore. Slide says it built everything from scratch, took extraordinary precautions, and that Datto's lawsuit is a distraction from a simple truth: better products win. I did the work on this. I purchased court filings from Delaware at $46 a document. I sat down with Slide's founders, Austin McChord and Michael Foss, for an on-the-record interview. I brought in a law professor and a trade secrets expert to break down what the allegations mean and what they don't. And I bring my own channel analysis expertise. Kaseya declined to comment, citing ongoing litigation. This isn't a press release. This is investigative reporting. The legal claims, the technical details, the market context, and the strategic implications for MSPs navigating a consolidating industry where litigation is increasingly used as a competitive strategy. By the end, you'll understand what's really at stake and why this case matters, whether you're a Datto partner, a Slide customer, or neither. This is a special report from the Business of Tech. Here's the case in plain English, grounded in the filings and correspondence. Datto LLC, now owned by Kaseya, sued Project Orca Incorporated, doing business as Slide, in the Delaware Court of Chancery, case number 2025-0975-LWW. Datto's verified complaint alleges 4 counts: trade secret misappropriation under Delaware's Uniform Trade Secrets Act, deceptive trade practices, tortious interference with prospective business relations, and unfair competition. At the center is Datto's Hardware Independent Restore, or HIR. According to the complaint, Datto describes HIR as a compilation of proprietary source code, algorithms, configuration parameters, libraries, methods, documentation, and know-how that enable near-instant recovery, booting a protected systems backup as a virtual machine across different hypervisors with minimal downtime. Datto says HIR does 3 things automatically and behind the scenes. Injects the appropriate storage and network drivers to match the target VM's virtual hardware, for example, swapping a physical RAID driver for KVM's VirtIO stack. Avoids relying on the original system's native boot volume by using an automated bootloader process tailored for virtual environments. Applies specific registry and configuration changes, including edge case fixes accumulated over years, to ensure the restored VM consistently boots. Datto claims these combined processes are closely guarded trade secrets, protected by access controls and employee confidentiality agreements. It alleges Slide, founded by Datto's former CEO and founder Austin McChord and former general counsel and chief people officer Michael Foss, misappropriated those secrets to fast-track a competing BCDR platform. Datto points to several items it says shows access and intent. Slide's public restore docs that list installing Red Hat signed VirtIO drivers, VioStore and Net KVM, and setting Windows SAN policy to online all. Slide's roughly 2-year build timeline and a statement characterizing the spend to reach launch as vanishingly small, and Slide's hiring of former Datto engineers. Datto also highlights public positioning and marketing. McChord's engagement with the phrase Datto minus Kaseya equals Slide, Slide's pitch that MSPs need a better BCDR, and an August event where McChord theatrically destroyed Datto hardware and offered to swap attendees' Datto gear for Slides. Datto frames this as disparagement and an attempt to trade on Datto's brand while converting its customers. Slide's answer denies misappropriation and the non-trade secret claims. Slide says its product was independently developed from the ground up over more than 18 months at significant cost, with active steps to avoid Datto code, trade secrets, or confidential information. It argues the specific HIR concept Datto elevates is not even useful for a modern BCDR platform, and that the boot volume changes and virt.io driver installs Datto sites are standard, transparent engineering practices for KVM-based virtualization, not evidence of using Datto's proprietary methods. On marketing and positioning, Slide acknowledges the August demonstration, but characterizes it as light-hearted showmanship, denies disparaging Datto, and says customer wins are due to Slide's product quality and service rather than any misuse of Datto IP. Legally, Slide raises defenses including failure to state a claim, preemption of the non-DUTSA counts, adequate remedy at law, failure to mitigate, justification/privilege, unclean hands, no extraterritorial application, and independent development. Datto moved to expedite on August 27, 2025, arguing irreparable harm and requesting trial within 6 months. The court has asked parties to propose a schedule with trial beginning around April 20th, 2026. If expedition is granted, the court will likely enter protective orders and compress discovery timelines. I'm releasing public versions of court-filed documents purchased from the Delaware docket such that should you wish to read and verify any of my work, you can do so with primary source documents. If you've never done this process, know that it's both kludgy and costly. The court charges $20 just to search, and yes, they even charge you to search, and that's per search. Then 6 documents at $46 each. Add in interviews, experts, and editing, this kind of coverage isn't cheap. But that's why the business of tech exists, to deliver real investigative reporting in the IT channel, not press release recycling, but independent analysis vendors don't always want out there. If you believe that matters, support it by becoming a member of Business of Tech Plus. That's at businessof.tech/plus. Not ready to subscribe? You can still help. On YouTube, hit subscribe and like. On audio podcasts, follow and auto-download. Advertisers and algorithms measure those signals. And yes, YouTube tips are on. Thank you, and on to more detail. Slide's founders agreed to sit down with me to respond to the allegations. Austin McChord is Slide's co-founder. He's also the founder and former CEO of Datto, the company now suing him. Michael Foss is Slide's co-founder and CEO. He was Datto's former general counsel and chief people officer. Before we get into the interview, context matters here. I reached out to Kaseya, Datto's parent company, for comment on this lawsuit. They declined, citing the ongoing legal matter. That means you're about to hear one side of this story. Keep that in mind. I'm not here to litigate the case or determine who's right. That's what the courts are for. But Slide's response to these allegations matters. MSPs are evaluating whether to bet on this platform, and they deserve to hear directly from the founders. Did they use Datto's trade secrets? What safeguards did they put in place during development? And why should MSPs trust them now that this lawsuit is public? I asked those questions. Here's what they told me. Well, Michael, Austin, thanks for joining me.
Thanks for having us.
Thanks.
Now, for those that aren't familiar, let's do the baseline real quick. What is Slide and what problem are you solving for MSPs?
Slide is a MSP backup company. We are bringing modern BCDR technology to the MSP community.
And how would you describe Slide's technology in plain language?
Slide is incredibly fast and incredibly capable and has been built from the ground up to run on an all-flash architecture, both on-prem and in the cloud. And when you have such powerful base layer, you can build all kinds of really cool stuff over top that.
There's some kind of innovation that you saw here that said, like, this is something new I can do. Tell me a little bit about what that is.
Solid state storage was getting less and less and less expensive. And so you actually cross this point where it's like, oh my gosh, I could actually run solid state storage in the cloud. This idea that you could build this all flash on-prem appliance that's going to be orders of magnitude faster than probably the machine that it's protecting, and that you can deliver an experience that's just an order of magnitude better than anything anybody else has.
Datto has alleged that Slide has, it's hardware independent restore. That's a really specific piece of technology. Can you talk me a little bit through how your approach is technically different?
We built our approach from scratch, and I couldn't tell you how Datto's approach works. But our approach is novel and takes advantage of all of the modern tooling that's available, and takes advantage of, many of the changes that have happened in the Windows boot process over the course of the last decade. And so we're able to build something new that's far more performant than we think the rest of the industry does.
We believe in the court system. Look at the answer that we filed. We do not use the HIR technology they're referring to.
Yeah, we don't use Datto trade secrets, full stop. And that's what we responded with and said, I'm sorry, I think you're mistaken here.
I'm sure you also then put some safeguards in place when you were doing development around Slide, so that you made sure that, you weren't leveraging anything that was a trade secret or prior knowledge that wasn't allowed. Talk to me through the safeguards you put in place during the development of Slide.
I wrote Datto's code in 2007. I also did not write Slide's HIR or sort of any of Slide's restore code. Slide is written in a completely different language than I have ever worked with before in my past. And that was done on purpose.
All of the founding engineers on the team hired a lawyer to make sure that they were all in compliance with all of their post-deployment obligations with all of their prior employers. But we did pay that lawyer for them to make sure, because our interests were aligned in ensuring that we had no access to, did not use any prior confidential information or any source code or any trade secrets or any of that.
Talk to me a little bit about kind of like what's sort of normal, and is that step additional process, or what do organizations broadly do in order to make sure that when they're bringing on new employees, they're not stepping on those lines?
Well, in a normal situation, you ask the employee in their offer letter to affirm that they are not using any prior employers or any other person's intellectual property. We were extraordinarily vigilant. We went through this extra annoying, expensive, time-consuming, onerous process of making sure for them, for the team, that they had no confidential information or trade secrets or code or anything from any employer.
How do you feel looking back on those kinds of marketing moves? Like how do you feel about it?
Where the disaster demo was our thing. And so coming up with a new novel way to simulate a disaster is like kind of on brand.
Yeah, I mean, like there is a place in this whole world for nerdlic fun. This is all in good fun and competition.
What would be your message to the MSPs about, why they should bet on Slide now with this case unresolved?
I mean, I think first and foremost, we didn't use Datto trade secrets in the creation of Slide, full stop. And we are excited and looking forward to the court process to prove that out. It's like, if you would like to come after Slide, build a better product.
When our partners use our product, they're the ones who can tell you how different it is.
I think that's a perfect place to end it. Gents, thank you. Really appreciate you talking with me today.
Thanks.
Thank you.
The full interview with Slide's founders is available exclusively for Business of Tech Plus subscribers. Don't miss that extended conversation, available at businessof.tech/plus to get access. So to help evaluate the technical claims in this case, I brought in Bob Zeidman. Bob is a software forensic expert and the founder of Software Analysis and Forensic Engineering. He's testified as an expert witness in over 100 intellectual property cases, including trade secret disputes in the software industry. Bob has developed methods and tools for comparing source code and determining whether one piece of software was copied from another or independently developed. He literally wrote the textbook on this. His methods have been peer-reviewed and are used by courts and corporations worldwide. Now, for this story, I'm not asking Bob to evaluate the specific code in this lawsuit. He hasn't been hired by either side and doesn't have access to the proprietary materials. Instead, I want his help understanding the technical questions at the heart of trade secret cases like this one. What makes technology protectable? How do experts distinguish between independent development and misappropriation? And can an engineer with domain expertise build similar technology without crossing legal lines? Bob, thanks for joining me.
Dave, thanks for having me on your show.
So let's dive right in. We're talking about what's protectable versus industry standard. So like in backup and disaster recovery, which I know you've got expertise in, what kind of technical approaches are typically protectable as those trade secrets versus what's considered industry standard practice?
Trade secrets are pretty broad. They can be anything ranging from things like customer lists to ideas and concepts and what they call negative know-how. So for example, when you're developing code, you go through a lot of things that don't work. The specific code could be a trade secret, even though the entire concept is very well known.
From a technical perspective, what evidence would convince you that a product was independently developed versus derived from a competitor's code?
If you run the code through my code suite tool, it comes up with numbers that are called correlation numbers, ranging from 0 to 100. So filter out open source code, filter out third-party code, filter out code that was written by the same person. When you've gone through the entire process and you still find a correlation that's non-zero, no matter how small, it could be a correlation of 1, that means that was copied. You need to find that one clue, the murder weapon, the bloody fingerprint. If I find 11 lines, those are the things that can only be explained by code copying. It doesn't mean that's the only thing that was copied. It means that's the only thing that's definitively copied. So then you can start branching out.
If a company says we built it in a completely different programming language from the original, how much does that prove independent development?
So it doesn't prove it. My tool compared different languages. If one company wrote code in C and the other one wrote in C++, it's not much of an argument because to translate from C to C is really simple. But if you're talking about C and Lisp, it's so different than every modern programming language that you'd probably have a hard time making a case that somebody copied from C to Lisp.
Can an engineer who worked on restore technology at company A later build similar functionality at company B without using trade secrets? Where's the line between personal expertise and misappropriation?
That's probably the most difficult part of trade secret litigation. California in particular has been modifying its laws, its employment laws, on a regular basis to say if you're a programmer and you've worked on backup systems, that you're able to work anywhere on backup systems because otherwise you're out of a job. So there's that balanced with you can work for another backup company, but you better not take any trade secrets. And then it gets into a very gray area. Did this person copy something that they learned at the first company that they shouldn't have? Or are they just practicing their trade, which is writing code for backup systems?
So if a restore technology, for example, was developed 15 or 20 years ago, can it still be a trade secret today?
It has to meet these three criteria. The trade secret needs to be not generally known to the public. It confers some sort of economic benefit on its holder. And the owner of the trade secret makes reasonable effort to keep it secret. If it's 15 years old, but still it's not known in the industry, then it's still a trade secret. That's the advantage of trade secrets over patents. Patents have a roughly 20-year period where you lose it, but trade secrets can go on and on forever. The only thing to know is that somebody can develop it independently. And in that case, there's no misappropriation.
If a company builds like a complete BCR platform in 18 to 24 months, does that timeline alone suggest they cut corners or copied?
So development timeline are clues, but not necessarily proof. So you find that a company got started and a month later, they have this huge program with all the code, hundreds of thousands or millions of lines of code that are written. That is not necessarily proof that they did something wrong or that they misappropriated your trade secrets. It's a pretty good indicator. What I like to say is that's an indicator that says we need to look further into this. You look at how many employees are working on it. When did they make changes to the code after that? Does any of the code match using the code comparison tool? You weigh the evidence, and if the evidence is way on one side, then that's a reasonable conclusion. Nothing's ever 100%.
Bob, thanks so much for joining me today.
Dave, thanks for having me.
The full interview with Bob Zeidman is available now exclusively for Business of Tech subscribers. Don't miss the extended conversation. Subscribe at businessof.tech/plus to get access. To understand the legal strategy and stakes in this case, I brought in Camilla Hrdy. Camilla is an associate professor of law at Rutgers Law School, an affiliated fellow at the Yale Law School Information Society Project, and a member of the Cydonia Conference Working Group on Trade Secrets. Her research focuses on trade secret law, non-competes, confidentiality agreements, and the intersection of IP law and innovation. She's published extensively in top law reviews, including the Yale Law Journal and Stanford Law Review. And she's a recognized expert on how trade secret litigation shapes competition and innovation in technology markets. I didn't ask Camilla to predict who will win this case or take a side. Instead, I wanted her help understanding the legal strategy at play. Why do plaintiffs choose trade secret claims over contract claims? What does expedition versus preliminary injunction signal? And how do courts actually evaluate whether something qualifies as a protectable trade secret versus industry standard practice? She responded in an email interview. In trade secret cases, when do you see plaintiffs plead breach of contract versus relying purely on trade secret misappropriation? What's the strategic difference? And Camilla's answer? There's likely no contract on point. For example, perhaps there is no non-compete or confidentiality agreement that would prevent what the defendant did, or else they don't think the contract is enforceable. Also, sometimes contract remedies are weak, so it's not worth bringing those claims if you think you have a good trade secret claim. So I asked, what does a plaintiff actually have to prove to win a trade secret case? Walk me through the elements under typical trade secret statutes. Her answer? Secrecy, meaning information is not generally known or readily ascertainable. Economic advantage derived from secrecy. Reasonable measures to protect the information. And a theory of misappropriation either based on breach of duty or based on improper means. My question? What's the difference between moving to expedite a case versus seeking a preliminary injunction? Why would a plaintiff choose one strategy over the other? Her answer? Sometimes plaintiffs just want things to move quickly. They want to get to discovery quickly. But you would choose a preliminary injunction if what was really important was stopping defendants and keeping secrets from coming out. I'm not a litigator. Maybe they don't think they can prove the elements of injunction. I often see motions to expedite discovery as well as motions for preliminary injunction at the same time. So perhaps there's a reason they don't feel confident about winning a PA at this stage. And maybe they just aren't that worried about getting a quick stop to whatever defendant is doing. My question? What percentage of trade secret cases actually go to trial versus settle? What drives the decision to settle versus proceed? And our answer? Super small. I just saw someone present data related to that. I can't remember, but I think it was under 10%, maybe even under 5%. That was Professor Camilla Hrdy's written perspective on the legal strategies behind trade secret cases. The key takeaway for MSPs? These disputes rarely go to trial, but the litigation process itself can shape the market, affect vendor stability, and influence partner choices. All the answers to my interview with Camilla are available for Business of Tech Plus subscribers. Visit businessof.tech/plus to get access right now. Why this fight matters now. This lawsuit doesn't exist in a vacuum. There's important context about where both companies stand financially and strategically. Kaseya in particular is reported to be carrying around $4 billion in debt, as reported in Channelholic. That's not a small burden. Debt service on that scale makes aggressive innovation harder. It crowds out R&D spending. And it creates an incentive to protect what you have, to defend incumbency, rather than take risks building the next thing MSPs actually want. Meanwhile, Datto itself was taken private in 2022. Its stock had stagnated and declined. The public markets had rejected Datto as a growth story, which made it ripe for acquisition. That's a weaker backdrop than either side wants to admit, but it helps explain why the company might prefer a courtroom fight to a product one. Here's the uncomfortable truth. In a consolidating market, litigation itself becomes a competitive tool. For incumbents, lawsuits can stall challengers, create fear, uncertainty, and doubt in the market, and reassure investors that leadership is defending the moat. For challengers, public fights can boost visibility and cast them as underdog innovators taking on entrenched powers. But for MSPs caught in the middle, the fight offers little tangible benefit. Courtroom outcomes rarely deliver the innovation or partner experience that service providers actually need. You don't get better backup technology because lawyers argued well in Delaware. Slide's rising risk profile. Slide was pitched to the market as a clean, innovative partner-first disruptor. In my own vendor brief, I flagged challenges like execution, integration maturity, and scaling support. I did not list legal jeopardy as a threat. That has now changed. For MSPs, this creates a new dimension of vendor risk. Even if Slide is right on the merits, litigation is distracting and expensive. An injunction, even a temporary one, could shake customer confidence or slow roadmap delivery. Early adopters need to weigh not just the technology, but whether the company has the runway to navigate a prolonged fight. So some lessons for MSPs on operations and law. This case isn't just about two vendors fighting in Delaware. It's also a cautionary tale for service providers themselves. There are practical takeaways in both operations and legal posture. Contracts beat secrets. One of the striking aspects of the Datto complaint is what's not there. There are no claims of breached contracts. That suggests Slide's founders and hires respected those restrictions. For MSPs, the lesson is simple. A strong contract is far easier to enforce than a trade secret claim. Don't rely on unwritten understandings. Put protections in writing. Most IP isn't IP. Many MSPs believe their workflows or tools are unique, when in reality they're industry standard. The legal bar for trade secrets is high. Information must be secret, valuable, and actively protected. Most providers would struggle to prove their special sauce qualifies. To qualify as a trade secret, information must be secret, have economic value from that secrecy, and be subject to reasonable measures. Providers should document these measures if they intend to claim protection. That doesn't mean execution isn't important. It just means don't assume legal protection where none exists. Litigation is a distraction. Even if you have a solid claim, lawsuits drain money, time, and focus. Watching two well-funded vendors spend millions on discovery and experts is a reminder. For MSPs, growth comes from execution, not legal battles. Put resources into productized services, customer relationships, and innovation instead of counting on courts to secure an advantage. And optics matter as much as facts. Slide's public relations campaign, interviews, unfinished business messaging, even stunts like burning Datto hardware, is about shaping perception. MSPs should note, when you face a crisis, whether legal, technical, or reputational, owning the narrative is as important as winning the argument. Your partners and customers respond to confidence. So here's my take. I expect this case to settle. Trade secret cases almost always do. Slide may face distraction and some legal costs, but I don't see lasting damage. The absence of contractual claims suggests their team was careful, and the reliance on technology dating back to 2007 highlights how much the industry has already moved on. For Kaseya, the reputational cost is higher. At a moment when they want to be seen as more channel-friendly under new leadership, this lawsuit makes them look defensive. Rather than demonstrating innovation, it signals that protecting turf through litigation is the priority. Want more from the Business of Tech? Join Business of Tech Plus for ad-free episodes, early interviews, extended cuts, subscriber-only shows, and exclusive member perks and analysis. Sign up at businessof.tech/plus. And follow this show in your podcast app, and if you're on YouTube, hit subscribe and the bell so you never miss a story. Reviews and comments help spread the word too. Interested in advertising? Head to mspradio.com/engage. The Business of Tech is written and produced by me, Dave Sobel, under ethics guidelines posted at businessof.tech. Thanks for listening. I'll see you on the next episode.
Part of the MSP Radio Network.